Hello everyone. If you're thinking about investing in bonds or other types of debt, you're essentially putting your hard-earned money into a company with the expectation of a return. This is a relationship built on trust, but trust alone isn't enough, it needs to be backed by rules and oversight. That's where the Trust Indenture Act of 1939 comes in. This law is your safety net, ensuring that the company you're investing in is held accountable. First up, let's talk more about the indenture. This is not just any contract, it's your investment's constitution. It outlines everything from how much interest you'll earn to what happens if things go south. Understanding the indenture is crucial because it's the document that spells out your rights and the company's obligations. Think of it as the user manual for your investment. If you don't read it, you won't know how to maximize your returns or what red flags to look out for. Now, even the best-written contract is useless if there's no one to enforce it. That's where the indenture trustee comes in. This entity is your advocate, responsible for making sure the company sticks to the terms laid out in the indenture. If the company fails to make an interest payment or breaches the contract in some other way, the trustee has the authority to take action. They can even go to court on behalf of bondholders if necessary. In essence, the trustee is your first line of defense against corporate misconduct. When it comes to actually receiving your returns, the paying agent is the entity that handles this. They're like the financial courier who ensures that your earnings reach your account. They manage the logistical side of the payments, making sure you get what you're owed, when you're owed it. If there's a delay or issue, the paying agent is typically your go-to for resolving it. You might also hear about the application for qualification. This is essentially the company's resume. It's a set of documents that the company submits to regulatory bodies to prove they meet all the legal and financial criteria to issue bonds. It's a critical step that adds an extra layer of security for investors. Voting security is another term that might come up. While not common in all bonds, some give you the right to vote on significant company decisions, like mergers or leadership changes. It's an added perk that gives you a more active role in your investment. Understanding these elements and their interplay is not just academic, it's practical. It equips you with the knowledge to scrutinize your investment options more effectively. The Trust Indenture Act of 1939 is like a quality assurance stamp. It ensures that the investment game is played on a level field, where both parties, investors and companies, are held to a high standard. One entity that plays a significant role in all of this is the Securities and Exchange Commission, SEC. Think of the SEC as the overarching referee that ensures everyone is playing by the rules set forth in the Trust Indenture Act of 1939. The SEC reviews the application for qualification and has the authority to approve or reject it based on whether the company meets the necessary criteria. This adds another layer of protection for you, ensuring that the company issuing the bonds has been vetted by a competent authority. One of the key principles behind the Trust Indenture Act is transparency. Companies are required to disclose a lot of information in their indenture and application for qualification. This includes their financial health, risks associated with the investment, and how they plan to use the money they raise. This level of transparency is designed to give you all the information you need to make an informed decision. It's like having a nutrition label on food, you know exactly what you're getting. What happens if a company doesn't follow the rules? The Trust Indenture Act has provisions for that too. Companies that violate the terms of the indenture can face legal consequences, including fines and other penalties. In extreme cases, the indenture trustee can take the company to court to protect the interests of the investors. This is your safety net.